Last time we talked about the rule against ambiguity. Now we're going to touch on the rule against duplicity. This rule is a count-based rule, just like the last one, meaning you cannot put two or more offenses in one single count. If you do so, it will be bad for duplicity. This is a good time to say this. If 6 people are murdered, you put the 6 deceased victims in 6 separate counts. Don't put everything together in one count. Now, unlike the last rule, this one has exceptions. Let's dive in. The first exception, where statutory forms are used. This is provided for by Section 193 of ACJA, that's the Administration of Criminal Justice Act. It says that a charge may be as in the form set out in the second schedule of this act, with modifications as may be necessary in the circumstances of each case. If there is a statutory form that combines 2 or more offenses, then you can put them as they are inside one count. If you check some laws, at the end where a schedule is, you will see provisions for 2 offenses put together. For example, housebreaking and stealing can be put together in the same count. What's happening there is that the law assumes that you break into a house in order to steal, so it just creates provision for it when it eventually happens. Now, if you are drafting a charge, instead of separating housebreaking and stealing into 2 separate counts, because the law gave it as an example, you can put them in one count. Second exception, allegation of general deficiency of money. This is another exception provided for in Section 197 of ACJA. I'm using ACJA as a baseline, but you can find them in the various ACJLs. Now let me explain the second exception. Imagine if someone working at the bank has been siphoning money from the bank at different times. This is what we call different transactions. For example, let's say he stole 1 million naira in March, he stole 3 million naira in May, he stole 12 million naira in July, and then stole 4 million in September. Now he has been caught. If they want to charge him, they don't need to separate the 4 different times he stole into separate counts. They'll just calculate the total and charge him in one single count. So instead of having 4 separate counts of 1 million, 3 million, 12 million, and 4 million, as long as he's stealing from the same property and it has to do with money, they can just put everything into one count of 20 million naira. And that's what he'll be charged for. Now, this exception won't count if what was stolen was not money. So if he stole 1 million naira in May, 1 gold bar in June, and 1 diamond in July from the same bank, you have to separate them into 3 different counts because the other 2 aren't money, only 1 is money. So 3 different counts, but all will still be in the same charge sheet. Third exception, offenses defined in the alternative. This exception is provided in Section 203 sub 1 of ACJA. And what this is simply saying is that in a written law, if an offense can be committed in different ways, it will usually state it in the same definition. To illustrate this, let's look at Section 356 sub 2 of the Criminal Code. Paragraph B of the section provides, any person who assaults, resists, or willfully obstructs a police officer while acting in the execution of his duty, or any person acting in aid of a police officer while so acting is guilty of a felony and is liable to imprisonment for 3 years. Take note of the any person who assaults, resists, or willfully obstructs here. This definition is alluding to the fact that the offense can be committed in 3 different ways, which are assaulting a police officer, resisting a police officer, and willfully obstructing a police officer. Now, where this is the case, you don't need to separate them into 3 different counts. Just put them all in one count. Fourth exception, similar or identical offenses committed in a single transaction. If the same person commits identical offenses in a single transaction, it can fall under the same count. For example, in the case of police Anoyewusi, the court held that demanding money with menaces and official corruption were identical offenses that had to do with extortion and could fall under the same count. Fifth exception, charges in respect of treasonable felonies. Now, when it comes to treason, to sustain such a charge, the Evidence Act provides that the prosecution has to show evidence of at least 1 or 2 overt acts in furtherance of the defendant's intention to commit treason or treasonable felonies. So when drafting, these overt acts can be put in the same count as the treason to corroborate it. Now that we've dealt with the exception, what is the effect of this rule? If a count is bad for duplicity, it does not necessarily invalidate the charge or trial unless the defendant can prove that it has occasioned a miscarriage of justice. If that is the case, then the charge can be nullified. And that is it for the rule against duplicity. The next rule we're going to talk about is the rule against misjoinder of offences. Thank you very much for watching my video. If you like what you just watched now, please like, subscribe, and share with your friends. Also, please feel free to hit the notification bell so that you get updates when my videos come out. Engaging with the content actually helps the algorithm see my videos, so I get to share it with more people. Don't worry, we'll be getting more content like this. Have a great day.